I just want to take a step back here, and we're talking about a former president. We're talking about the front runner in one of the two major parties. And as an American, as a lawyer, when you hear that they are disqualified from a state's primary ballot, what's your reaction?
Well, my reaction is there's a host of legal issues that are implicated by this case, not the least of which, and all of which the Colorado court found in favor of the plaintiffs are. Is the president an officer of the United States within the terms of the 14th Amendment? People have argued, and the court held that while the president and vice president are conspicuously absent from all the other host of people who are named, the implication of having an office under the United States includes the president and vice president. So that's one issue. The second issue, which is a very delicate one in the law, is this amendment self-executing, or does it require some action by Congress? Because one of the provisions of the 14th Amendment says, like the 13th, 14th, and other amendments do, say that Congress can implement this amendment by legislation. So there's been a fight over whether that requires some other action besides what a plaintiff would file in a state court. Beyond that, there's a question of what's an insurrection, because the amendment doesn't define it. Now, there's a criminal insurrection statute, but Trump wasn't charged with that. And so there's a factual dispute, and there was in the Colorado court, about whether he engaged in an insurrection. And then that's the last piece, is did he, through what he did, through the speech on the ellipse, through his tweets, through his other actions, did he engage in an insurrection? And that's essentially a free speech issue under Brandsburg v. Hayes, which says that you have to use fighting words. You have to use words that imply or intend to incite violence or riot. And so that's the other question. The court answered that in the affirmative. So there's a host of legal issues. And now this has all been thrown in a cauldron of other cases into the lap of the Supreme Court. And the confluence of other cases, I think, complicates this. There's already pending a petition by the special counsel to determine whether Trump's motion to dismiss, alleging that he's immune from suit, has to be decided quickly because there's a trial scheduled for March 4th. There's another case pending, which involves 18 U.S.C. 1512, which is the obstruction statute, under which the government has convicted 327 people. It's a 20-year felony, which is, in my view, why the government used it. And now the court has taken a case to determine whether the type of actions that these people were charged with is within the obstruction statute, which was essentially a post-Enron statute to prevent people from destroying evidence or obstructing the investigation through limiting evidence. And the argument is, well, that's not what happened here. And so the question before the court is what's the intent, what's the reach of that statute? So the court has three cases in front of it, one of which they've accepted, and they're all related in some sense because Trump has been charged with 1512. So any decision by the court to void the use of 1512 in any of these prosecutions would mean that one leg of their case against him would be knocked out.